Welcome to today's episode where we dive into the essentials of estate planning with a focus on blended families. This is part 2 of a 2-part series on planning for blended families. And today we are going to explore the critical documents important for every blended family and the consequences of not having those documents. We'll also talk about some strategies that you can put into place when you have a blended family. I am Tammi Caress, your host for today's episode, and you're listening to Navigating Estate Planning with Caress Law.
And now it's time for the disclaimer. The information contained in this podcast and associated material is intended to furnish listeners and users with general information on matters that they may find to be of interest. The information in this podcast provided by Caress Law and its agents are for general guidance and is not intended to replace or serve as a substitute for any advisory, tax, estate planning, or other professional or legal advice, consultation, or service. Sometimes we may reference third-party materials or websites. Such links or references are only for the convenience of the listener, user, or browser. Caress Law and its agents do not recommend or endorse the content of third-party information or sites. You should consult with appropriate Caress Law professionals or other professional advisors for advice concerning specific tax, estate planning, or other matters before making any decision. In summary, this podcast is not legal advice. If you need legal advice or before acting or making any decision with anything talked about in the podcast, seek the counsel of an attorney. Thanks so much.
Wills and trusts. I have a prior episode talking extensively about wills and trusts and the differences between the two. So I highly encourage you to go back and listen to that episode if you want to learn more. For today's purposes, I am going to briefly summarize the difference. One is a will. List your beneficiary, or you name your beneficiaries in your will who inherits from you when you die. This beneficiary, in order to inherit under the will have to wait out the probate process before they inherit. And that is why people like to put into place living trusts or revocable trusts. Same thing, just different name, same thing. These types of trusts are typically created for several primary reasons, but I would say the primary reason is to avoid probate. The trust accomplishes the same thing as the will in that you identify who your beneficiaries are, who will inherit from you, and how, but it avoids probate. That means it's a private document. Any asset or any will that goes through probate is a matter of public record, so everyone can see it. Lots of people like privacy when we're dealing with trusts, and it avoids probate. It avoids probate because we fund the trust during your lifetime. That means that we take assets and instead of in your individual name, we put it into the name of the trust. An example is a home. A home is usually in your individual name, but if you create a trust, we're going to convey it to the trust. You, wearing a trustee hat, have complete control over that home during your lifetime, and the document names a successor trustee who will govern those trust assets if you're incapacitated, or upon your death, will disperse those assets pursuant to the trust terms. The trust is different than the will because A, it avoids probate, and B, it's relevant during your lifetime. Once you create it and put assets into it, you're managing those assets during your lifetime. And if you're incapacitated, another person gets to manage it, whoever you have nominated in that trust to do so. Again, if you want to learn more, please go back and listen to some prior podcasts that explain these documents in more detail, and also the probate process, which is governed by the will. So what happens if you don't have these documents? The state will choose who inherits from you at death. That's what happens. And also, if you don't have these documents and you are incapacitated during your lifetime, the state also chooses who gets to make decisions for you. So, very important to have these documents and some others in place. When it comes to blended families, This is super impactful because typically when you're not in a blended family and you're married and you have kids from the same partner, then oftentimes documents will say, I give everything to my spouse because you're confident that your spouse will ultimately support and give your assets to your children that you have together. But in a blended family, this may not be exactly what you want. You may not have children together. You may want to provide for your spouse, but ensure that your children inherit from you at some point, maybe when the survivor passes away. If you allow the state to make those decisions for you, the state is going to allocate your assets, usually based on a percentage, to whoever is surviving you, which will be your spouse and your children, since we're talking blended families today. So your spouse will receive some of the assets and your children will receive some of the assets. Now, I have seen some very terrible outcomes because of this, because the decedent did not put their documents together. One outcome that I know I've mentioned in other podcasts, and I think it's because it just stands out so much in my brain, is a gentleman who told his family what he wanted when he was terminally ill, did not write it down, assumed his family would do the right thing, not understanding that state law governs what the right thing is in this situation, and effectively made his spouse of 30 years move from their family home that they have lived in longer than they were married. What happened is the spouse was entitled to a third of the assets. His adult children were entitled to 2/3 of the assets under state law. And surviving spouse was kicked out of her home because it had to be sold so that the children could receive their 2/3 share under state law. This was a terrible situation because not only is it an outcome the decedent didn't want, but the surviving spouse ended up being very angry with her deceased spouse and also losing what she thought or who she thought were her family. The 2 kids, the adult children, she helped raise and considered them just like her own children. And that relationship is forever broken. Terrible outcome. Terrible. The other consideration is when you don't have these documents in place, but you still want to avoid probate, many people will go and say, well, let's just put all of our accounts as jointly owned and make sure we have each other on the accounts as beneficiaries. This does accomplish avoiding probate, but what it also accomplishes is you have now effectively disinherited your children when you do this. I have a client or counseled clients in the past who tried to avoid probate by doing this. Ultimately, they didn't avoid probate, by the way. It's rare, but also you're putting your family in a position of disharmony, essentially. You're putting them in disharmony, and you can cause a lot of family arguments because you didn't actually lay out your wishes and you tried to divvy it up in this manner. Not only that, it makes it very hard to have someone in charge to file your final tax returns, and the IRS, I have seen this, the IRS ultimately goes after the beneficiaries. So it's a terrible spot for a lot of reasons. Anyhow, not having anything in place with a blended family almost always ends up in a situation with the division of assets and distribution of the assets that was unintended. And you can put your spouse or even your kids in a situation that puts them in a poorer situation than they were before. The other consideration with a blended family is when you don't put anything in place and you have minor children and they inherit, it typically is your children's other parent who gets control of the money. And most people who are divorced, if they're on their second marriage due to a divorce, they don't want their spouse or their ex-spouse to have access to their money, even if it is for their children. So a lot of reasons to put a will or a trust in place when you're a blended family. Really quick, I want to talk about the benefits of a trust for blended families. Yes, a trust can avoid probate, but another good reason is if you want to minimize any objections to your documents, keeping it out of the probate court just helps you minimize those kinds of objections. If you have a beneficiary who you are concerned might object to your will, a trust, because it is a private document, does not go through probate, and therefore there's no forum immediately available for that beneficiary to cause problems. So that's a really good reason to have a trust. And the reason is probate, because it's so public and the probate court requires the personal representative / executor to give notice to any person who inherits, who would have inherited if the decedent died without a will, then they will receive notice under the probate court. But of a trust, the only people who are legally entitled to a copy of that trust in most jurisdictions is the beneficiary actually named. So if you want to minimize any sort of litigation and objections, a trust is a really great way to go. And like I said before, it's a private document. That way, the only people who are involved with that trust are those that you name in it and your successor trustee. It's also much easier to implement estate tax planning when you have a trust than when you have a will. There is one benefit to having a will and wanting to go through probate. I actually had a client who had 2 children who did not get along at all. And she wanted to name her 2 children as the personal representative of the wills. And she wanted specifically to go through probate because these 2 children fought, and she wanted the court to be there for supervision, if you will. So I suppose that's a benefit. I don't think that is the best course, because there's other things that can be done without court intervention to kind of mitigate that situation. And one is hiring a professional trustee, which I'm going to talk about here in a little bit. But when you look at the benefits of a will over a trust, I would say a trust is definitely more beneficial. But if you're looking at the benefits of a will over having nothing, the will is definitely a document that you should put in place. All right, so planning for minor children and stepchildren. In your will or your trust, you get to name who the guardian will be over your minor children. And like I said in the prior episode, although you definitely need to talk this through and there's some considerations with who and how, in the documents is how you name somebody to be in that role. And there are different states that have rules, and they differ from state to state regarding guardianships and who is eligible, if you will, to serve in that role. For example, Oregon is a state that will act in the best interest of the child. And so if you name someone in your will, the court will take that under consideration, but that's not the only thing they look at. There are other states that if you name a person to it to be a guardian of your minor children under your will, that is the important piece, and you likely will succeed in having that person named. Ensuring that your ex-spouse is not in control of money. So when you have minor children, what's great is in the estate plan, you can actually put assets in trust for them. And this can happen after you're gone. We design it in your estate plan That trust goes on to support your minor children, and you get to name a trustee who is not your ex-spouse to be in control of that money. Now, I do have some clients that they're okay with their ex-spouse being in control of the kids' money. That's great. I mean, I think if you're in a relationship where you each are always acting in the best interest of your children, that's wonderful. But for the most part, most of my clients do not want their ex-spouse to have control over inheritance received from you to your children. So when you're planning for minor children, that's something that we can put in place to ensure that your children, the assets they inherit are protected, and you get to name who is the person overseeing those assets while your children are young. In the documents, we can also address potential conflicts among siblings. This is where a professional trustee comes in. When you have a blended family and you're really worried about one side over the other, who's going to be the one that controls the money, who's going to be the one that has decisions over health concerns or health decisions, then it can be challenging, especially when we're in the blended family planning stage. This is where professional fiduciaries can be really great because they are a neutral third party. And professional fiduciaries have an obligation to act in the beneficiary's best interest. And they have to follow the terms in the documents that you set out. And I had to tell you, it is a big job to settle someone's estate. And a lot of times, if you want it gives you peace of mind to hire a professional to do that. So you relieve the burden amongst your family. And if you're really concerned about the conflicts amongst maybe children and stepchildren, professional fiduciary is a really great way to go. Life insurance is an amazing tool. You can use it for so many things. When we're in a blended family, life insurance can be a really great way to fund a trust at death for your spouse. And maybe your kids get other assets or vice versa. Maybe the life insurance proceeds go to your kids and your spouse gets other assets that isn't life insurance, but it's a way to help provide for both the spouse and children. Life insurance is a really great tool for other things, but it's especially useful when we're dealing with blended families. Some spousal considerations in blended families, there are laws that we call elective share laws. Now, an elective share law, if the jurisdiction has this type of law, means that a spouse is entitled to a certain percentage of their deceased spouse's estate. I actually talk about this a lot with my clients, especially with my blended families. So when we're looking at estate planning, we want to make sure that either that elective share law has been waived by both spouses, both parties, if they like to keep their assets separate, or we want to make sure that the assets are set up and your will and trust are set up in a way that accomplishes the elective share laws, but also your wishes, which might be that you get to determine where your assets ultimately go once your spouse passes away. So something to be cognizant about. Another strategy that we often employ with estate planning, especially with blended families, is we can give your assets to a spouse and they get to use them during their lifetime. But when that spouse passes, maybe the principal goes to your children from your prior relationship. We call this an irrevocable trust, and there's lots of names for irrevocable trusts. In fact, you can name your irrevocable trust anything you want. But this is a very common tool to provide for your spouse during his or her lifetime, but then guarantee assets go out to children. It's a really great strategy. I do have clients from blended families who keep a lot of their assets separate, and they do that intentionally. Maybe they got together much later in life and they want to make sure their individual children are provided for. So we actually will create 2 separate trusts, one for each of them. And then we might put some accounts or maybe even the home in title that is jointly owned by the spouses so that they pass outside of the trust to the surviving spouse. But then inside the trust, we develop those techniques that either give the assets to your own children, or maybe they continue on in trust for the surviving spouse, knowing that principal will ultimately go out to children at some time. So those are a few strategies that we can do with spousal share. Blended families, I have seen some beautiful families come together, and they, even after parents are gone, they still have a wonderful relationship. Unfortunately, that is not always the case. So the more clear that you can be in your documents, the better. And also, communication is super important. That first example that I provided, the deceased person did communicate with his family what he wanted. He just didn't put it in documents. I often will have meetings with my clients and their kids, even their blended family kids together. And it doesn't mean I have to divulge any sort of specific asset detail and values of things, but a lot of times I am laying out what's going to happen. One thing is showing the kids that, hey, this is how it's set up. Yes, when your father passes away and your stepmother inherits, she is not inheriting assets outright. They're going to stay in trust. It's an irrevocable trust, so she can't change it. She gets to receive all the income. But guess what? When she's gone, that trust says that everything goes out to you kids. I see this being a bone of contention when we're dealing with family property. An example could be farmland that's been in the family for multiple generations, and then a new spouse comes along. The kids can get really worried that that new spouse is going to inherit that property. Well, we can actually allow that new spouse to continue living in or on that property, but guarantee that that property will go out to the children once she's deceased. So there are lots of ways that we can make sure that everyone in the end inherits how the decedent intended. The biggest thing, though, is managing expectations so that you can reduce any sort of potential conflicts. So I like having the family meetings so that I can really show them how assets will pass and what it means, and they get to ask questions. It's just a really great tool. I'm a neutral third party, amongst this family. Yes, I'm acting in the best interest of my clients, but it's just a really great way to kind of bring the family together, allow them to ask questions. And I have seen relief kind of, I see the shoulders relax and a little bit of relief when we kind of go through things so that people understand what's going to happen. And it's very useful too, like I said, when we're using insurance so that we can design the whole plan. When I do estate plans, I look at everything and I look at it comprehensively. We look at what assets are going to be in the trust, what assets can't be in the trust, and therefore we're adding beneficiaries to those assets, what assets will stay joint, those kind of things. And we look at this with family members when we're looking at the comprehensive estate plan with communication. So communication is super important. I will say communication is not just, yes, I put things in place, everything's going to you. No, I can't tell you how many times I have had children come to me that say, My dad said he put a will in place and everything went to his children, but we can't find the will and I don't know where it's at. I think it's a good idea if they at least are introduced to your lawyer or if you give them a copy of the document. Now, a lot of people, their will or trust, a lot of people don't want to do that, and that's okay as long as you tell them how to find it or where to find it once you're gone. But having those important conversations with your family so that they understand what will happen, especially with blended families, I think can really help in reducing potential conflicts. Some practical steps and things to consider. Please work with your attorney. This episode does not even remotely encompass what goes into designing an estate plan, but there are lots of ways for assets to pass at death. An estate plan kind of puts them all together to make sure they pass in the way intended. Always review your beneficiary designations and retirement accounts and insurance policy. With blended families, we ask for a copy of that divorce decree because a lot of times there are requirements in that divorce decree that impact your estate plan. One might be the requirement to have an insurance policy. Another might be the requirement that a retirement account is designated to kids. So definitely keep your papers in one spot, open them up, look at them once in a while. And it's also important, especially when we're dealing with divorce decrees that have specific estate planning agreements in them. It's important for those who will be in charge of settling your estate to know that. Because if they don't, they may never know if they never come across these documents. So putting those types of documents with your estate plan is super, super important. All right. I hope this episode was useful for you today. My main takeaways for you are with blended families, it's super important to have a will or trust in place. And it is extremely important to work with an attorney so that you can understand all your rights and your intended can ultimately be put down on legal documentation to make sure that they're carried out. All right. Well, I'm going to go ahead and put a few episodes in the show notes below. And if you could, please give us a Google review, and I'll leave that review in the show notes as well. We have a lot of other resources on our website. We have on-demand free webinars that really go into some of the topics I briefly touched on today. We also have a blog and we have a lot of resources that you can download on our website. So if you're interested, please check that out. And I hope you enjoyed listening today, and we'll see you next time.